Hi, I'm attorney John Cannon with Cannon Associates, and today I'm going to be speaking to the issue of whether you should go to trial by judge or by jury. In Oklahoma, both parties in a criminal case have the right to trial by jury. Most people don't recognize that. So, in order for you to elect to have a trial by a bench trial or a trial by judge alone, the prosecution must also waive their right to a jury trial. So, what are some reasons that someone may want to waive having a jury trial and proceed on a bench trial? Some litigation, especially complex criminal cases, involve legal issues that are too complex for a jury. Oftentimes, you'll want a judge alone to consider whether the evidence that the state has presented is sufficient to meet the specific elements for the crime that you're charged with. Under Oklahoma law, and really the laws of any state, there are specific elements that the government must prove in order to show your guilt or prove you guilty at a jury trial or a bench trial. For instance, crimes that require specific intent, crimes such as the desire to commit a specific type of fraud, or other types of crimes that require specific intentional acts that you didn't only commit the crime, but you intended to commit the crime. That may be a circumstance where a party may want to waive the jury and only proceed by a bench trial or judge alone trial. Another common area that litigants may decide that they want to waive their right to a jury trial and have a bench trial is when the subject matter or the issues before the court or a jury are offensive, concerning, something that you don't want to deal with, the perception of you, the perception of your cause by a jury considering that fact as well. In some instances, people will waive the right to a jury trial in a sex offense case that has specific intent requirements because you're dealing with the issue of not only telling your narrative, explaining to the jury that the government can't prove your guilt beyond a reasonable doubt, what the law and issues are, but also trying to take away the animus or take away the perception about what crime you've been charged with. The benefit of a bench trial on issues that are offensive or negatively impacted by public concern or perception problems or deeply complex legal issues is that in a bench alone trial, you don't have to explain to the court the burden of proof. You don't have to worry about perception of the court because the judge is supposed to, and if you have the right judge, it's safe to assume, will set aside those misconceptions, set aside perceptions about what you're charged with, and have laser focus in on what the legal issues are and the standards that the government may meet. So, in summary, in criminal cases, you have the right to a jury trial, but you also can seek a bench trial. However, if you're going to waive your right to a jury trial, the prosecution has the same right, and they must agree to waive the right to a jury trial as well in order for you to have a bench trial or a judge alone trial. Another benefit of one of these proceedings is that the time it takes to try a case on a bench alone trial is much shorter. Some people in traffic citation trials will elect to have a bench trial only so that they don't have to worry about picking a jury, getting the right people to hear and consider the issues. You can just get to the facts and nitty gritty, and your criminal defense attorney can fight for you in court on that issue. I hope this video has been helpful explaining the considerations in a bench trial versus a jury trial. If you have any other questions, please feel free to visit our website, jpcannonlawfirm.com, or you can leave your questions or comments in this video and we'll get to your questions and be sure to answer them. If you haven't already, please take a moment to click the subscribe button here for more useful videos by our firm, and please feel free to reach out if you have any questions.